Welcome, eavesdroppers, to Conversations in Coffee, the video and audio podcast where stimulating discussions flow as smoothly as a fresh cup of coffee. I'm Dr. Joy, the host of this show. Join me as we delve into captivating topics with fascinating guests, which will lead to thought-provoking conversations and heartwarming stories. Are you into the latest trends? Well, we're here to caffeinate your mind and ignite your curiosity. So grab your favorite mug, settle in, and let's brew up some captivating conversations together. This is Conversations in Coffee with Dr. Joy, where every sip sparks a new conversation. Today, we are diving into part 2 of elder law and estate planning with attorney Mortellaro. Let's get started with this conversation. As you were talking, you were mentioning things such as, power of attorney and trust and your will. Should a person have a power of attorney, healthcare surrogate, and so on? And the reason I ask, because sometimes you think just the power of attorney does everything. But when you have children, more than one, you may want one to do something and another to do something else. What can you tell us what we should have?
So at minimum, 3 core documents. The first document is that durable power of attorney. Now that only handles legal and financial decision-making. So to your point, many people say, oh, I have power of attorney for mom, and I say, well, do you have the healthcare surrogate or the medical power of attorney, as it's called in some states? And they go, no, I just have power of attorney. Mm-hmm. Well, then that means you might be able to write a check for mom, pay her bills, or talk to the bank, but you may not be able to talk to her doctors and make medical decisions. Kind of need both. So in Florida, by statute, we call it a healthcare surrogate. Other states call it a medical proxy or a medical power of attorney. But the idea is you want all 3 of the big categories covered: legal, financial, usually those are done in the same document, and then medical. Medical is done in a separate document. The medical, actually, they're very important, needs to not only appoint who you want to step in and be able to make healthcare decisions for you, but it also needs to have what's called a HIPAA release. HIPAA is a 1996 piece of federal legislation, but for our purposes, it restricts the hospitals, doctors, and anybody related to your healthcare from giving any protected health information to a third party without your consent. And that can even be your spouse. So if you think about it, if you were to call your husband, let's say had a biopsy, and he's busy at work, but you can't wait for the results, and you call his doctor and say, hey, you got the results of my husband's biopsy. I want to make sure he doesn't have cancer. Mm-hmm. Without them having authority to talk to you, they're going to say, I'm sorry, Miss Boyd. We have the results, but we can't tell you anything about it unless your husband gives us the authority to talk to you. Mm-hmm. Well, as long as he's alive and healthy, he could certainly tell the doctor, hey, whenever my wife calls, talk to her. But your husband were to be in an accident or have a stroke and not be able to tell the doctor on the fly, you better show up at that doctor with a quality document that allows them to release information to you, as well as take instructions from you. So I have this all the time, that even documents written well after 1996 say, oh, I appoint my daughter Joy to make my medical decisions for me. Mm-hmm. The end. Mm-hmm. But nothing in this document gives the medical professionals the ability to talk to Joy and tell her what's going on with you, but she can make decisions. So you need to make sure the document is holistic in nature and has all of the bases covered. So that's a big one. So the first document is power of attorney. Second is healthcare surrogate or medical power of attorney. Third document is usually the living will. And the living will gets confused with last will and testament, and they both get confused with revocable living trust. The living will is a healthcare document, and for lack of a more politically correct term to explain it, it's the pull my plug or don't pull my plug document if I have ever lost capacity to make my own decisions, the only way to keep me alive is on a machine like a feeding tube or a ventilator, and the doctors all agree that I'm not going to get better, stronger, and come off of the machines barring some miracle, what do you want to happen? So many of your listeners probably remember back from the early 2000s, the case here in Florida of Terri Schiavo. Mm-hmm. Terri Schiavo was made national news for about a decade. She was in her 20s when she had a medical crisis that left her unable to make her own decisions and arguably in a persistent vegetative state. And her husband and her parents spent a decade in court and millions of dollars in legal fees fighting over what they thought Terri wanted. Well, if Terri had a 3-page document that said, hey guys, if I ever end up with no brain activity in a persistent vegetative state, and the only way to keep me alive is on a machine, thank you, but no thank you. Or in the alternative, if she said, I don't want to die, keep me alive, keep me plugged in. Mm-hmm. Whatever she said in that document, we would have never known her name because her wishes would have just been followed. Yeah. But first of all, people in their 20s certainly think they're invincible. So yes. Very rarely do they have documents in place. But as we get older, and to kind of circle back to your previous question, when's the right time? 18. Mm-hmm. And in fact, a lot of my clients and what we do under our legacy care program for our parents and grandparents, that as long as they are a legacy care client with us, which means we have an ongoing relationship for the estate planning and elder law, as their children and grandchildren turn 18, we offer those documents because many parents don't realize you send your kid off to college and they have the hold my beer and watch this moment, and they end up in the emergency room. And, you know, Mama Bear comes trekking in the emergency room wanting to ask questions and make decisions. She may have the very unpleasant experience of being told, ma'am, I'm sorry. You're still biological mama, but you are no longer legal mama because Junior here is now 19. And so we can't tell you what's going on and we can't let you make decisions unless you have some documentation. So I'm a big fan of when the child turns 18, allowing them as their own adult to choose who do they want to make their legal, medical, financial decisions. We've had a lot of cases where especially young men, motorcycle accidents, traumatic brain injuries, they're in their 20s and 30s, and no one thinks about these things. But if we have the documents in place and a crisis happens, at least, you know, we have somebody that immediately can step in, make decisions, get information, pay the bills, those types of things.
Wow. I'm just remembering at 18 years old when my son started college, and, you know, they telling us this story about, oh, you're still mama, but you can't get the grades and you can't get this, you can't get that. And I'm like, what? You know, I'm paying the bill.
Yeah, really.
Like the same thing here.
If you want that tuition bill paid next week, we're going to talk about this.
You better make sure you better sign saying I can have permission.
There you go.
You're right. The same thing with this as well. Wow. Never thought.
It's a broader topic. So, you know, elder law and estate planning is for 18-year-olds too.
It is. It is. You are throwing out so much good information today. I thank you for that, because I am getting an earful myself, you know, just making sure that I have things in place. I'm getting ready. My son is getting ready. My other son is getting ready to turn 18. And we didn't do that for my now 23-year-old, but definitely that's something we're going to have a conversation about when.
And your 23-year-old now should have it just in case.
You're right. You're right. We'll see if he'll give it to me.
Yeah, that's the thing is that he becomes the client. So if he says, my mama's crazy and I'm not going to let her make any decisions for me, that puts me in an awkward situation, but I have to follow the instructions of the client, which may be an 18-year-old who may or may not be making great choices. Yeah. But I'd rather them have some choice than no choice.
You're so right. You're so right about that. So basically, I think my next question is answered. You can protect your assets by attaining an attorney, elder law attorney.
Yeah,
definitely.
Every state is different. And some states like New York are notoriously difficult to protect assets within the 5 years of needing care. Mm-hmm. And other states like Florida are arguably the best in the country, because I've had cases, you know, I've done 6,000 Medicaid cases, never had a denial, and I've sheltered over $800 million for clients and their families in the last 17 years. Some of those families had 5,000 in assets. Our largest single case had 7.2 million in assets. So anywhere on the spectrum, we can be effective. The earlier that we put things in place, the better. However, if you are in Florida or you have a family member in Florida that's getting old, needing care, and you have that sinking feeling that you've missed the planning window because you don't have 5 good years before mom's in the nursing home because she's already there, don't despair. Still contact an attorney. In other states, they may tell you there's not much they can do. In Florida, I can immediately get mom on Medicaid, shelter whatever assets she has. And if you've been private paying at 10 or 20,000 a month for the last few months, I can usually recapture that for the family even after they've paid the bill.
Now, let me ask this. You're talking about from state to state. So for an example, if someone looks at this and they say, oh, I want to go with this law firm, even though I stay in California, could they not do that? Or how?
My philosophy, and other attorneys may differ because they want to cash every check that is comes in the front door. My philosophy is I want to only take on a case when I know that I can make a difference. And I truly feel I know my way around the detailed rules of that state. And so if you came to me in California and said, listen, I saw your podcast and I really like you, and I'd like for you to take care of my mom in California, I'm going to say, thank you. I appreciate the opportunity, but let me connect you with a colleague that I have personally vetted who's in California, who I think is as smart in California law as I am in Florida law. But I would be doing you a disservice by trying to get you a Medi-Cal, which is what they call it in California, when I'm really not up to speed as much as I should be on their laws. And I'd be taking your money and learning on you, and that's never best for the client. Now, that being said, the VA benefits that we offer, those work the same nationwide, even worldwide. I've done VA benefits for people that have retired outside of the country. So for VA benefits, I will be able to help families all across the country because there's not a state or a local component as there is in Medicaid and general estate planning.
Okay. Thank you. I wanted that to have that inside of what we were talking about today, because I know sometimes when people look at things, they're like, I want that person.
Go back, go to Google, type in highest rated elder law attorney in blank state or blank city, and start looking at the reviews, read the reviews. And very quickly, I think you'll be able to find the best of the best.
Yes. How can you avoid probate court?
So probate is a sucker's game that makes lawyers money. I do it as part of my practice, so I can say that with a straight face.
That. I keep telling her, Mom, I hope you're listening. I'm telling you.
It's true. At any time in my office, we can have over 100 probates running concurrently, but those were not my clients before they died, by and large, 98, 99%. Occasionally, after I educate someone on why probate avoidance is a good thing, and honestly, I'm working myself out of bigger fees as I'm educating them that you don't want to go through probate. Occasionally, I have someone that says, I'll be dead then. Who cares? If it takes a little longer, the kids have to go through a little more, so be it. Okay. I've done my job. I've educated, and your mental wiring has given you the indication that who cares, I'll be dead, then I'm fine. I will absolutely do your probate and I'll make every penny on it. But for those folks that aren't wired that way, which is there's not many, is I tell them, if you like your children or your church or your charities or whatever it is, if you like them more than you like lawyers, judges in the court system, okay, I'll be happy to take your money. But chances are you probably have someone or some cause more near and dear to your heart than even your favorite lawyer. So the idea is that you have a choice. In Florida, probate is minimum 6 to 12 months. So your assets are frozen for the majority of that time. You have attorney's fees, court costs, filing fees, publication fees, bond, paralegal fees, and personal representative fees that all dollar for dollar come out of the hands of your beneficiaries. So it's extremely inefficient timing wise. It's inefficient financially. And the state of Florida, for the most part, gives me a statutory fee as a probate attorney of 3% of your assets, which on first impression seems like a relatively small number, like, oh, we still got 97% left. But it's not uncommon for people to have, $500,000 in assets when you add everything up, especially with home prices. And if they have a vacation house or a rental home, business owners, that's a whole nother story. Business owners need to have their businesses coordinated with their estate plan, or their business is going to most likely get shut down for the 6 to 12 months while it's going through probate. What's your business going to be worth after 12 months and nobody answering the phone?
Yeah.
Not a whole lot. So we have choices to create efficiency. Usually that's done by trusts or specialty deeds. But the idea is that I have never once in my thousands of probates that I've done, I've never had a family come to me after probate and say, boy, that was a great experience. I can't wait for my next family member to die so we can hire you again and go through this again. In fact, the opposite is true. When I take a family through probate for one of their loved ones who's passed away, a very high percentage of the time, at some point during or after the representation, they call me and go, all right, that was terrible. No offense. But what do I need to do so that my kids don't have to go through what I just went through with my parents? Boom. That's how we grow the estate planning business. Unfortunately, sometimes those decisions are made following a painful process if they hadn't been educated early enough.
Yes. Education is the key. Education is the key. We are now, trying to make sure that our parents are being more educated on this. Do you feel that the reason people go through probate is because they have a will? And then
yes.
That is okay. So if they have a trust, it's
so different. Most likely, again, I'm generalizing. Most likely, if you have no documents, you're going to be going through probate. If you have a simple last will and testament, the last will and testament is your roadmap through probate. It tells the probate judge who to put in charge of your estate, your personal representative or your executor, and it tells the judge who to leave your assets to. The ways around probate, now there are some creative titling, joint ownership, rights of survivorship, beneficiary designations. There's ways you could cobble together a DIY or a do-it-yourself project that may be effective at avoiding probate, but the best way to do it, the most comprehensive with the most amount of safeguards, is usually a trust. That is going to be your go-to gold standard for avoiding probate. There was actually a very interesting case, just got settled in, I want to say, end of January, early February of 23. So just this year, a gentleman in Chicago, Illinois, passed away, never married, no children, and was predeceased by his parents predeceased him and his siblings. This guy had $11 million of assets. So that's a huge estate. Passed away in 2017. His probate just got finished in 2023. So you got 5 years, 5 to 6 years of probate. And his $11 million was split up between 119 distant great nieces and nephews that he had never met. Now, I didn't know that guy, but I got to think if I asked him the day before he died, like, hey, who do you want to get your stuff? It probably wasn't going to be the 119 family members I've never met. You're right. Maybe he had a church. Maybe he had a charity. Maybe he had a friend or a cause that he wanted to support. Or maybe he was into education. With $11 million, you could create one heck of a scholarship fund for, minorities or disabled people or people of your religion, or whatever. It doesn't really matter.
Yeah.
My guess is he would have done something different than just let it go into the system, because the system took hundreds and hundreds of thousands of dollars and then spit it out to people that he had never met before. Doesn't seem like it's the logical approach.
You're right. So through elder law, firms, they can help with the family trust or
Absolutely. Yeah. We've done thousands and thousands of them.
okay. And that's part of the process as well when you attain an elder law attorney.
Yeah. Yeah, that's where the cross section, where all elder law attorneys are also estate planning attorneys.
Okay.
So we do all the traditional estate planning documents, but the beauty is that when you do get older, if you do need care, you already have the relationship in place, and your lawyer can now do the part B, as opposed to being in your 30s, 40s, 50s, going to a traditional estate planner that doesn't do elder law. And specifically, if you are a veteran or widow of a veteran, you want that elder law attorney to also be VA accredited, because you don't want to wait until your time of need when you're highly stressed out and then call your attorney only for them to tell you, oh, I'm sorry, we don't do elder law, you're going to have to find another attorney. That's not when you want to go shopping for a new professional. It's nice to call the law firm that you're already have been with and say, hey, you guys did my documents 20 years ago. Well, now I'm old and sick. I need your help. And them to say, sure, Mrs. Jones, jump right on that. I'm so sorry that, things aren't going well for you healthcare wise, but we already have all your documents on file. We know that you're a widow of a veteran. We can immediately jump in and get these benefits for you. We can get Medicaid for you. It's a smoother transition to getting old, to not have to go out and build a new relationship. But there's a lot of my clients now that are not old. In fact, they're the children and grandchildren of some of my old clients.
Okay.
And they're in their 20s, 30s, 40s, and they love working with us because they know that we'll grow with them and we'll be there, and if I'm not here anymore, I already have a legacy, succession plan built into the law firm. So the law firm will still be here, even if I'm not, down the road when they need us.
Let me ask this. You are located in Tampa Bay area, but can anyone come to you in the state of Florida?
Absolutely. All 67 counties, Key West to Pensacola, we serve them all. Okay. A lot of it we do virtually, and COVID was actually, I guess, kind of a good thing for distance professionals, because everybody got comfortable with Zoom, and everybody, they're seeing their doctors through telehealth. So what's wrong with seeing your lawyers through, telelegal, whatever you want to call it. And so for our clients that are outside the area, it's not a convenient drive to our office. All of their legal documents are prepared here in our Tampa office. And then we will send a mobile notary and witnesses out to their home, their community, at no charge. So they're not being inconvenienced by using a law firm that may not be right down the street.
Okay. All right. Super, super. I think we're winding down as far as the questions I have. Let me add, the last question that I kind of wanted to ask you is, what is the cost? What is the cost associated with an elder law attorney?
So pretty broad spectrum. Part of that spectrum is based on experience. Part of it is based on market. So you're going to probably pay more in New York City than you would in, some suburb. So I would say cost is somewhat relative to the attorney's experience in the area and reputation. But even within, let's say, our law firm, we offer trusts that are $1,000 and we offer trusts that are $50,000. They do very different things, and they're for very different market segments based on assets, based on mostly asset protection. So when people call me and they say, I need you to protect my assets, my first question is, well, what assets are we protecting? And from whom are we protecting them? Are we worried that you're going to get in a car accident and get sued, or that your 18-year-old, hopefully I don't jinx you on this, your 18-year-old, borrows your car and gets in a terrible car accident because they're texting and now you're getting sued? Yeah. That's a very different type of asset protection than I'm getting old and I'm going to need a nursing home, and I don't want Medicaid to force me to spend down my money at the nursing home. So it depends on what you have and what your goals are. We do a lot of asset protection. In fact, I have several companies, but the law firm is my brick and mortar business. But then I'm also co-founder of a company called Fortress Asset Protection, We work with business owners, entrepreneurs, real property investors to identify areas of legal risk. If you got sued, what can that plaintiff go after? And we want to make that target as small as possible by taking your business interests and protecting them, your real property, your rental properties, your vacation homes, your car collection, your, cash in the safe in your house. We want to identify all those assets and figure out, if I was the plaintiff's attorney and I'm going after it right now, as we sit, back to education, what could I get at? There's certain things in Florida they can't get at. Typically, your home is protected. Cash value of life insurance, cash value of annuities, 401ks and IRAs. Those are already creditor protected from like personal injury lawsuits, but many of them are not protected from Medicaid or veterans benefits. So really a thorough analysis of what do you have and what are we trying to accomplish? And then again, I have trusts that are 1,000, I have trusts that are 50,000, everywhere in between. So the fees will be varying based on complexity of the case and what we're trying to accomplish.
Okay. Oh, wow. I mean, I just have so many questions going through, and I know, our time is just kind of winding down, but I know
we're good. If you ever want to follow up, or if your viewers want to submit questions to you and we can jump on at a later time and do a question and answer, happy to do it.
Oh, wow. Thank you so much, because I mean, this is so much information, but is needed, especially before you get to that point. And that is what our podcast is all about. It's about getting information before it's too late, or getting information before you're in the emergency, the now.
Sure. I get it.
Okay, so I want to sum up our conversation by having some fun a little bit. So let's get into something I call 5-second thoughts, and your answers are more personal than they are professional, okay?
So this is dangerous territory.
So try to think of the first word that pops into your mind, and you can repeat the same statement that I say so it flows better with the word that I use. So this is the first one. Today I am.
Can't do this on the fly. All right, I got. Today I am grateful.
Me too. I am grateful that you are here with our eavesdroppers and giving us so much information. And I am hoping to call you back because I got so much going on myself. Yes.
I love it. I love it.
Our conversation was
productive.
It was. Thank you so much. When you laugh, or when I laugh, I laugh.
Oh, genuinely.
Me too.
You never get a courtesy laugh. If it's not funny, I'm not giving you a courtesy laugh.
We're on the same page with that one. My personality is
witty. At least I hope so. I like to fancy myself as witty.
And then your last one is, I love what I do because.
I love what I do because there is never a Monday I wake up and think I got to go to work. I wake up every Monday and I get to go to work. I get to work with amazing people, hear their life stories, protect what they've built. A lot or a little doesn't really matter. Whatever they have is important to them. And so I get to help protect that and really provide for them in a roundabout way, especially like our veterans and widows of veterans. It just really makes my day when I can allow someone to get the care they need and protect the assets they have and leave them in a better place that I found them. And that's what I love about what I do.
Oh, wow. And you summed it up. I mean, that is awesome, because when you get to that point that you love what you do, you can just go in, like you said, on that Monday morning and do your job. That's awesome.
I tell people white space on the calendar or space on your calendar without an appointment is the devil. So I book my days, 8:30 in the morning until 6 at night, back to back all day, because I want to have contact with and hopefully a positive effect on as many people as I can meet every single day.
Me too. Me too. Thank you so much. So
thank you for the opportunity.
You're so welcome. I just want to thank you again for being a part of Conversations in Coffee. It is always a great experience when we can learn more to help us live our best lives. My hope is that our eavesdroppers today have learned a lot through your knowledge. So one more thing, eavesdroppers, I would love to keep the conversation going. We are ready to tackle questions and comments. And you heard him. He said he'll come back if we have some questions. So ask away. And we will see you next time on Conversations in Coffee with Dr. Joy.